We're going to go ahead and get started. Folks probably saw that we'll be recording today's webinar, but I just want to let everyone know that verbally as well. Happy Monday. Thank you for joining us. I hope all that were celebrating holidays this weekend had a joyful holiday. And we are going to dive into today's very exciting webinar, the newly passed Pregnant Workers Fairness Act and PUMP Act, what state and local partners need to know. If we move to the next slide, just a little bit about A Better Balance. We are a national legal advocacy organization. We have offices in 5 locations now in New York City, where we're headquartered, Nashville, Tennessee, Denver, Colorado, New Orleans, Louisiana, and Washington, D.C. At A Better Balance, we use the power of the law to advance justice for workers so they can care for themselves and their loved ones without jeopardizing their economic security. And today you'll be joined by me. I'm Sarah Brofman. I'm National Policy Director here at A Better Balance, and my colleague Lisa Garcia, who is a staff attorney here at A Better Balance. All right, let's dive in a little bit into what we're going to cover today. So we have a lot to cover because we have 2 new federal laws that one of which has gone into effect, one of which is going into effect. And it's a really exciting moment for the state of pregnant and postpartum workers' rights in the workplace. So first, we're going to do a little bit of background on the PWFA, the Pregnant Workers Fairness Act, and the PUMP Act. Then we're going to explain the interaction between those 2 federal laws and state and local laws, because there are some comparable state and local laws. And then we're going to talk just a very short bit about rulemaking, which what I mean by that is the Equal Employment Opportunity Commission, which is going to enforce the Pregnant Workers Fairness Act, is responsible for coming up with regulations on the Pregnant Workers Fairness Act by the end of this year. And there is a whole process for how those regulations come about, and we're going to talk a little bit about those. And then we're going to talk about how workers can enforce their rights, because these are 2 really exciting laws with very meaningful enforcement to them. And lastly, I know folks have a lot of questions, and so we are going to save time to take as many questions as we can. I want to encourage folks, though, to please stay in touch with us. I imagine that some things we say today may foster more questions as you've had some time to think things through, and we are available to take questions following this. So please don't feel like today is your only bite at the apple if you have questions coming out of this presentation. Let's jump into some background on the Pregnant Workers Fairness Act and the PUMP Act. So in front of you, you see a timeline, and that timeline only covers a 7-day period in 2022. But as we're going to see, both of these campaigns to pass these laws were 10 years in the making. Each of them took a decade to get across the finish line in Congress. And really, it's been quite a journey, and a journey that many of you have been on with us to see both of these become law. But just to give you a little bit of the snapshot of what happened at the end of last year and where we're going now. So at the end of 2022, right as Congress was about to end, it was really the last hope to pass the Pregnant Workers Fairness Act and the PUMP Act in this Congress. And they were passed as amendments to the very large budget bill called the Omnibus Spending Bill. They were both passed as amendments to the omnibus bill in quite dramatic fashion for those who may have been following along closely. But both of them garnered very overwhelming bipartisan support at the end of 2022. In a vote of 73-24 on the Pregnant Workers Fairness Act, and a vote of 92-5 on the Pump for Nursing Mothers Act in the Senate. And so it was really a testament to the work of so many folks that are on this webinar that there was such resounding support to have really strong protections for pregnant and nursing parents that we all really needed to see come to fruition. On December 29th, President Biden signed the omnibus into law, and the PUMP Act, which we'll talk more about, it's expanded provisions to millions more workers to provide break time and space, went into effect immediately. And it's expanded enforcement provisions, which extended remedies, goes into effect in a couple of weeks now, on April 28th, 2023. The Pregnant Workers Fairness Act is going to go into effect in just a couple of months on June 27th of 2023. And like I said earlier, the EEOC is going to issue regulations by the end of this year. So taking a step back, if we go to the next slide, we'll see that the fight, and we're just going to take a snapshot really of the Pregnant Workers Fairness Act, because this has been a decade-long fight. It began in 2012 when A Better Balance's co-founder and co-president Tina Baxt wrote an op-ed in the New York Times called Pregnant and Pushed Out of the Job, which identified a really upsetting issue, which was that pregnant and postpartum workers were being forced out of work because they needed small changes at work, like lifting help, like temporary transfer, like a stool to sit on if they needed a reprieve because they're a cashier, basic things to maintain one's health while pregnant. But employers were not providing those. And that was largely due to a gap in our federal laws. I won't get into the real weeds of that. And we'll talk a little bit about what laws are on the books already, especially before the law goes into effect on the 27th. But suffice to say, there were real gaps in the law that necessitated a fix in our federal law. And that's how the Pregnant Workers Fairness Act was born. At the same time as the federal bill was introduced, we knew that workers needed these protections right away. And so 2013 kicked off some really exciting state momentum, which many of you have been a part of, making the case for the maternal health benefits, the economic security benefits, the business benefits to having a clear, real, affirmative right to accommodations at work. So the first state in this sort of new wave of pregnant workers' fairness laws was New York City. I should say the first city to do it. And then that really inspired many more states to take action. So in 2014 alone, 4 more states passed pregnant workers' fairness laws. In 2015, the federal PWFA had its first bipartisan introduction following a lot of state-level bipartisanship. Then we saw in a 3-year period, 14 more states pass pregnant worker fairness laws. In 2018, there was a front page New York Times article about how several women at a warehouse in Tennessee were denied accommodations, which led to really severe health consequences, including miscarriage, because they were denied accommodations, and sort of re-sparked and re-energized this movement to finally get a federal fix. In 2019, we put out a report called Long Overdue, highlighting these continued gaps in our law that were leaving workers without protections. And it was story after story that we're hearing on our helpline, which we'll talk more about. And Lisa will talk more about our helpline, where we were hearing over and over that pregnant workers were being denied accommodations and pushed out, and the law was not on their side. Over 2/3 of workers who were filing cases under the Federal Pregnancy Discrimination Act, which has been on the book for 40 years, weren't getting the accommodations they needed because of some real gaps in the law. So between 2019 and 2022, again, we had more states coming to the table and passing laws, and it just became so clear that there needed to be a federal fix here, that there were now 30 states, DC, 4 cities that had these protections and 20 states without them. And it shouldn't depend on luck or location in order to get some real protections to maintain your pregnancy and a steady income. And after 2 congressional hearings where our co-president Dina testified, along with other partners, with business partners, with workers sharing their own stories, including a client of the ACLU's, Michelle Durham, really making the case for why this is good policy and ultimately led to a very strong bipartisan vote twice in the House of Representatives, and finally the culmination of these really strong votes in the Senate in late December of 2022. So if we move on to the next slide, really, this is about a time of celebration. And it's a celebration both of all the work that was done in the states and the work federally as well. Like I mentioned, there are now 30 states and DC and 4 localities that already have very strong pregnant worker fairness laws, meaning employers have to provide reasonable accommodations unless it would be an undue hardship for them. And it's just been incredibly exciting to see these states in action and to see these laws working for workers. The difference that we hear from workers in states where we can say there's a clear law on the books, you can talk to your employer, you can resolve this right away, versus the states where there weren't any protections. And we saw really unfortunate consequences of that is just night and day. And so this is really just a testament to all the work that has been done in the states and the real protections. Because a lot of times folks say, oh, well, the states are just, the end result is really the federal, but state laws and passing state protections are important in and of themselves because they grant protections to millions of workers in real time that don't have them. And for 10 years, there have been growing protections for those workers. So if we move on to our next slide, we're going to talk a little bit about the significance of these new laws. And it's hard to sum them up in really broad strokes, but just to sort of paint the picture by numbers, the Pregnant Workers Fairness Act, which provides reasonable accommodations for limitations related to pregnancy, childbirth, and related medical conditions, so long as they don't impose an undue hardship on employers, will extend protections to over 3 million pregnant people and millions of postpartum workers each year. So the 3 million number really represents the number of pregnant people that there are each year in the US, but we know these protections extend also to postpartum workers, and there are millions more postpartum workers as well. And like I mentioned, and we'll talk a little bit more about, there are really robust enforcement provisions in these laws as well. And so these are meaningful rights for workers to take advantage of. And when there are violations, there's real enforcement and remedies for workers whose rights are violated. Now, the Pump for Nursing Mothers Act is an incredibly exciting, momentous victory as well. For those that may not be familiar, in 2010, the Break Time for Nursing Mothers Law was passed as a part of the Affordable Care Act, and that extended break time and space rights to millions of workers, but only those that were covered by the Fair Labor Standards Act overtime provisions, which meant that there were really the haves and the have-nots when it came to break time and space. And there were 9 million workers who weren't covered by those protections. And so under federal law, didn't have access to reasonable break time and space to pump at work. The original law also didn't have very strong enforcement as well. So it was really hard, even for workers that were covered, to meaningfully remedy any violations. And so those are two really sort of top line features of the Pump for Nursing Mothers Act, was closing that gap and extending protections to nearly every worker in almost all industries, and putting real meaningful enforcement provisions into the law as well. Now we can move on to the next slide. So the Pregnant Workers Fairness Act, like I said, goes into effect on June 27th of 2023. The law applies to people who work for the government and for private employers with at least 15 employees, which folks might know that federal law, Title VII, and the Americans with Disabilities Act, those laws also cover private employers of 15 or more employees. So it tracks those. Now, what can workers do under this law? They can request accommodations, and employers must engage with them in good faith to find an accommodation that meets the worker's needs, unless that accommodation would be too difficult or too expensive for the employer. Another really important feature here is that retaliation for requesting an accommodation, for using an accommodation is illegal, because we were finding that workers were even being penalized for asking for accommodations. And we wanted to make sure that not being forced out of your job is a key feature of the Pregnant Workers Fairness Act. So you can really think about it as both, it's the right to accommodations, but it's also the right to request these accommodations to be protected for that as well. Now, in terms of the enforcement, workers have to first file a complaint with the Equal Employment Opportunity Commission before filing a lawsuit. So it is possible to file lawsuits, but before you file a lawsuit, you have to file a complaint with the EEOC, the Equal Employment Opportunity Commission, or a state level agency. And we'll talk a little bit about that as well. If we move on to the next slide, we're going to talk a little bit about examples of reasonable accommodations. So reasonable accommodations is a broad term. It's an individual assessment between the worker and their employer about what that worker might need. And two different pregnant workers within the same workplace might need different accommodations. One might need no accommodations, one might need accommodations. And it's really an individualized assessment between the worker and their employer. So just some examples of what reasonable accommodations can include. And I think it's really important. This is really a crucial and kind of crux of the law, is understanding the broad scope of reasonable accommodations. So light duty can be a reasonable accommodation, temporary transfer, additional breaks, right? Whether that be bathroom breaks or food and drink breaks, flexible scheduling for prenatal or postnatal appointments, right? If someone needs to change their schedule so they can attend a prenatal appointment or needs leave to take a prenatal appointment, time off. So I think it's really important to understand that leave can be a reasonable accommodation. The Pregnant Workers Fairness Act really tracks the Americans with Disabilities Act, which has this very similar framework that for workers with disabilities, they can get reasonable accommodations unless it would cause an undue hardship. The Pregnant Workers Fairness Act incorporates the same framework there with some slight modifications in certain circumstances, but that the crux of that is similar. And under the ADA, so just like under the ADA, where leave can be an accommodation, so too can leave be an accommodation in the Pregnant Workers Fairness Act context. So what do we mean by that? If someone needs leave to recover from childbirth, right? Recall it's limitations related to pregnancy, childbirth, and related medical conditions. So if someone needs time off to recover from childbirth, time off to recover from a miscarriage, if they need bed rest before going out for childbirth, if someone has mastitis, and more. And something that's really important is for many workers that aren't covered by the Family and Medical Leave Act, which Lisa will talk about, the Family and Medical Leave Act provides unpaid leave that's job protected for childbirth as well as pregnancy-related needs, but there are very stringent eligibility requirements. One of which is that you have to work for an employer with 50 or more employees, 50. The Pregnant Workers Fairness Act is really potentially a stopgap for those workers who aren't covered by the FMLA, don't have that unpaid job protected leave under federal law, but now they can turn potentially to the Pregnant Workers Fairness Act if they work for a covered employer there to get unpaid but job protected leave following childbirth. It can include reasonable accommodations, can include changes to food or drink policies. They can include making existing facilities easier to use, changes to uniform, changes to your work schedule, including telework or remote work. They also include, and this is important in terms of the relationship between the PWFA and the Pump for Nursing Mothers Act, the PWFA also includes accommodations for lactation-related needs. So that includes break time and space, but it also includes other lactation-related needs, right? So if someone needs a uniform change because they're breastfeeding, that could be an accommodation that isn't necessarily available under the Pump Act, but is available under the PWFA. So the two laws really work together to create very strong protections for lactating workers. And it also includes accommodation for mental health conditions, right? For postpartum depression, perinatal depression, if someone needs accommodations related to that, whether that be appointments to see mental health providers, whether that mean, again, potential time off related to that, it's inclusive of those as well. So let's go to our next slide. And now we're going to talk a little bit more about the PUMP Act. So the PUMP Act expands the right to receive reasonable break time, and this is really important, each time the employee has a need, and a clean private space to express milk to nearly 9 million more workers, as we discussed, including teachers, registered nurses, farm workers, and many others. And this portion of the law, as I mentioned, is already in effect. So this expanded coverage to millions more workers under federal law is already in effect. And it provides protections for up to 1 year following the birth of an employee's child. We'll talk a little bit about state level protections. I know, for instance, there are some states that go beyond 1 year. Those protections remain in place, but the federal law is up to 1 year and it applies to employers of all sizes. So this has been something that's sort of been confusing since 2010. But there is something in the law that says employers with fewer than 50 employees can claim an undue hardship exemption. Some people have thought that meant that employers with fewer than 50 employees are exempt from the PUMP Act. That is absolutely not the case. All employers are required, of all sizes, are required to comply. However, employers with fewer than 50 employees can claim that it might be too difficult or too expensive. But I want to say about the undue hardship exemption, both in PUMP and PWFA, that is a fairly high bar to meet. And so we really encourage employers to engage with employees because there are so many ways to find creative solutions for break time and space. There are so many creative ways to find pregnancy accommodations for workers. And that's what we really want to encourage folks to do. For certain employees of rail carriers and motor coaches, the law will go into effect in December of 2025. So there's a bit of a longer lead time there for certain rail employees and motor coach employees. And unfortunately, the law does not apply to flight attendants and to pilots, so air crew members. It does, however, apply to other airline employees. This is a really important feature. And I think it's important to note that the Pregnant Workers Fairness Act would apply to flight attendants and pilots. So for flight attendants and pilots that may need lactation accommodations, they may be able to turn to the Pregnant Workers Fairness Act for protections. Workers under the PUMP Act can file lawsuits for violations. This is something new that is in the law that wasn't in the Break Time for Nursing Mothers Act, which is that they can file lawsuits for violations. They don't need to go to the Department of Labor, which enforces the PUMP Act, before filing a lawsuit. This portion of the law that allows workers to file lawsuits goes into effect in 2 weeks' time on April 28th, 2023. And just as a reminder, because I know it can be confusing with different agencies, the Department of Labor enforces the PUMP Act, and the Equal Employment Opportunity Commission enforces the Pregnant Workers Fairness Act. What's really nice, however, is that the EEOC and the DOL have been really trying to work together. In fact, tomorrow we have a colleague that's presenting on another webinar related to Black mothers at work for Black Maternal Health Week that's being put on by the EEOC and the DOL because they have been doing some really great coordination with one another. If we move on to our next slide. So there's lots of questions about, does this have to be paid break time for pumping at work? The answer is no. The time does not have to be paid under federal law. However, if an employee is performing any work while they're pumping, then that time counts as what's called hours worked, and it has to be factored into calculating minimum wage and overtime for those workers who are making minimum wage and receiving overtime, meaning that time has to be calculated towards considering whether someone is pushed over into overtime eligibility. The other thing I'll say is that If workers in the workplace are being compensated for other types of breaks, it may be the case that workers also have to be compensated for break time and space, because that could potentially be a violation of other types of laws like anti-discrimination laws, where the employer is providing pay for certain types of breaks, but not to their lactating workers, which could be a problem as well. We definitely encourage folks, and I think you'll see at the bottom of each of these slides is our helpline number. We really encourage folks to call us with questions around that, because we know that can be a confusing area. The other feature of the PUMP Act that we wanted to note is that before you file a lawsuit under the PUMP Act, if it's related to a space violation, not related to break time violation, but if it's an employee saying the employer didn't provide adequate space, then the employee has to notify the employer 10 days before filing a lawsuit to give them time to try to correct for the violation. But again, they're not required to first file with the Department of Labor. They just have to give the employer some notice. They don't, however, have to give employer notice around the space issue if the employer has already terminated the employee for exercising their rights, or if the employer has indicated that they don't intend to ever provide the space. So if the employer has been clear about that they're really not going to comply, then the worker doesn't have to wait 10 days to correct. But we really want to emphasize that this 10-day period, that's too long, right? We know that's too long when it comes to pumping, and when workers don't have the space they need, that employers really need to try to correct that immediately. The 10-day period is really just for filing this lawsuit, but we want to encourage employers to remedy any sort of, if it is a misunderstanding, immediately. Moving on to our next slide. So we're going to talk a little bit about the PWFA's interaction with state laws. As I mentioned, there are 30 states, as well as DC, and 4 localities that have very similar laws to the Federal Pregnant Workers Fairness Act. And what do I mean by very similar? I mean that because it was really a concerted movement to pass the Pregnant Workers Fairness Act in both states and in Congress, the laws were really designed to be very similar. And so the framework of employers needing to provide reasonable accommodations, unless it would be an undue hardship, is fairly consistent in almost all of these states. The biggest feature of the state laws and the federal law is that the state laws remained in place. So they were not what's called, in sort of legal terms, preempted. So what preempted means is that the federal government can sometimes say, we just passed this federal law, this kind of wipes away all of the state level laws. That is absolutely not the case, both with the Pregnant Workers Fairness Act and with the PUMP Act. So state level break time and space laws and state level pregnant worker fairness laws are both still in effect, and workers now have rights under both state law and under federal law. Now, certain states have, and folks may know this, like I said, the Pregnant Workers Fairness Act applies to employers with 15 or more employees. Certain states have pregnant worker fairness laws that apply to more employers. So there are many states that have human rights laws that apply to 4 or more employers with 4 or more employees, or employers with 3 or more employees. We put here just a couple of examples. These are not exhaustive, but for instance, New Mexico has their pregnant worker fairness law applies to employers with 4 or more, Connecticut 3 or more, Oregon 6 or more. There are some states with 1 or more, like New York. And so for those who don't have the protection under the federal law, these state laws are still really, really important, particularly for those who are working for the very smallest of employers, where the state law might provide more coverage. There are a couple of state level pregnant worker fairness laws that only apply to public sector, but most of the laws apply to both private and public sector workers, and again, follow this consistent pattern. As a follow-up to this call, and I should say, We are going to be sharing lots of follow-up information. I know we're throwing a ton of information at you all today, but we're going to follow this up with a new resource that we are going to be releasing in our follow-up email, where we're going to talk about where we provide information about the federal law and about each of the state laws, so that you have information on both the federal protection and the state protection. And we really want to encourage folks to come to us with questions about whether it be about your state law and its interaction with the federal law, whether it be about talking with your state agency that enforces the state level law, if there's questions about how state level agencies can provide more information, we want to be there every step of the way with you. And this is by no means the end. This is really the beginning, because we want folks to stay engaged and start getting the word out and start letting folks know in as much detail as they can. And so to the extent we can be helpful in charting that path for you in your particular state, we are here to do that with you. If we move on to PUMP, many states also have laws providing protections for lactating workers expressing milk in the workplace. And several, again, of those states mirror the PUMP Act in requiring unpaid break time and space. And again, like I said, similar to the Pregnant Workers Fairness Act, the PUMP Act does not preempt those state laws or those local laws. Those are all still in effect. Now, enforcement of these laws varies from state to state. Some states have really not strong remedies when it comes to their break time and space laws. Some states do. And some states even go, like I said, beyond federal law, where the protections are for beyond 1 year, or there are 3 states, Illinois, Georgia, and Minnesota, that provide for paid breaks for workers. So it's important to continue to keep both the federal law and the state law in mind. And I think what's sort of an easy way to think about the state-federal interaction is when you hear anything related to the PUMP Act or the Pregnant Workers Fairness Act, which you likely will over the coming months, because when federal laws go into effect, there's a lot more conversation and attention. Just think to yourself, I wonder if my state has a corollary and if there's an additional level of protection. But again, come to us if you have any questions, and we'll be putting out materials, both that you'll be getting soon in your inbox, and then a series of materials related to these questions as well. So we're going to be with you for the long haul here. When it comes to the PUMP Act and the DOL wasn't tasked with coming up with regulations the same way the EEOC was on the Pregnant Workers Fairness Act, but the DOL has been doing a great job putting out fact sheets. They put out a new fact sheet, new FAQs to provide guidance and enforce the law as well. So they're taking this new law really seriously as well, and they certainly want to be hearing from folks too when it comes to the PUMP Act as well. Moving to our next slide. We'll take a little pause to breathe here. So our next slide is on EEOC rulemaking. And like I said, the Equal Employment Opportunity Commission is going to do what's called promulgating regulations on the Pregnant Workers Fairness Act. And what that means is that they have the text of the law in front of them, and there are all sorts of questions that they can delve further into in explaining how various components of the law work. And they first will put out a notice of proposed rulemaking, and they will seek comment on those proposed rules. And that's really an opportunity for folks to weigh in with input on how we believe the law should be interpreted. And anyone is permitted to submit comments. You don't need to be a lawyer to submit comments. It's really important for the EEOC to be hearing from a wide array of stakeholders. And I know there's so many folks on this call who are working in the maternal health space, who are working in the lactation space, who are working on state level labor and workers' rights issues. And it's really important for the EEOC to hear it from a wide array of folks. But you may be thinking to yourself, well, how am I supposed to, I don't know the first thing about federal rulemaking. And that's another area where we are going to work closely on providing resources, things like templates, where you can work off of them to submit comments to the EEOC so that we make the process as easy as possible for you to submit comments and make your voice heard so that we ensure these are the strongest protections possible. And before I turn it over to my colleague, Lisa, who's going to talk a little bit more about the federal laws that are already in place that are overlaid with these and that are really important protections as well, I think we may have missed one of our slides that had a bunch of photos and joyful moments over the course of the campaign. And I just want to take the opportunity to thank each and every one of you who are on this call. You all worked tirelessly on state level campaigns that lasted years. And those campaigns might have come to fruition, they might have not, but every single one of those campaigns was instrumental in making the maternal health case, in making the economic justice case, in making the business case for the Pregnant Workers Fairness Act, both in your state and at the federal level. And we just want to send our heartfelt thanks for your partnership, for your continued partnership all along the way and for years to come, because as we keep saying in the couple months that we've just passed, since we've passed these laws, this is just the beginning, right? Federal laws and all laws are only as good as people knowing about them, whether that be patients, clients, people in your community. And we want to make sure the word is spread far and wide on these and that they are the strongest protections possible, but they wouldn't have been possible without some really tireless advocacy, writing letters, rallying with us, taking out ads in newspapers all across the country, bringing folks to DC to talk with your legislators, sharing stories about your communities. You know, it's you're innumerable to name, but our maternal health partners, our labor partners, our economic justice partners, our racial justice partners, our civil rights partners, our business partners, our faith partners, you've all been so instrumental and just a joy to build this movement with and to build this community with. And we're so excited to keep building that with you all here. So let me turn it over to Lisa to talk about some of the federal laws to keep in the back of your mind as well when it comes to protections for pregnant and postpartum workers.
Thanks, Sarah. Yes, and as you mentioned, apart from the PWFA and PUMP, we wanted to give a broader scope of the protections that exist right now. There are other federal laws that we'll discuss briefly, and they're currently in effect, and they'll still be in effect once PWFA and PUMP fully take over. And so workers need to be mindful that they can bring legal claims under multiple laws. When doing so, they won't be able to get more than one monetary award. So for example, if a worker files a complaint and they're awarded back pay, they would only be able to get the back pay once, even if their employer will violate a few of the laws that we discussed today. And as many of you know, part of why we passed the PWFA and PUMP was to fill gaps in federal law, especially for low-wage workers. But we wanted to make sure that you know that we did not preempt or invalidate existing protections, which could still be helpful in certain contexts. So the first example we have here is the Pregnancy Discrimination Act, for short PDA 101. Many of you might be familiar with it, and we discussed it previously already today, but it prohibits unfair treatment of workers because of their pregnancy, childbirth, or related medical condition. An employer can't treat an employee that's pregnant differently from other workers based on their pregnancy alone. Here we give an example of if an employer cuts a pregnant worker's hours, but not others because that worker is pregnant, then this could be a violation of the law. The PDA here applies when employees are pregnant, but we can also keep in mind that it may protect employees who are not yet pregnant, meaning that they're trying to conceive or have already given birth postpartum. Also with the PDA, harassment based on an employee's pregnancy is also illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision like being fired or being demoted. And the harasser, when somebody's suffering this type of discrimination, can be the victim's supervisor, a supervisor that's in a different department from you, a coworker, or someone who is not an employee, like a customer. Moving on to the FMLA, the Family and Medical Leave Act. This was also discussed a bit earlier, but it can still interact with existing protections for all workers. Typically, it's a federal law allowing workers that qualify to take leave for a set of narrow reasons, including one serious health condition, to care for a parent, child, or spouse that has a serious health condition, to bond with a new child, or for certain active duty military members and their purposes. But it is limited in scope for who's covered under the FMLA, typically just government employees and employees at a workplace that has at least 50 employees and whose workers have worked at least 1,250 hours within the past year. So those qualifiers alone can limit certain workers, especially those that are part-time or those that work for smaller employers. But under the FMLA, it provides job protection, meaning that you can go to your prior job or an equivalent position, and people are protected from retaliation when they're on FMLA. What the PWFA does is it fills the gaps for many in the FMLA context because it provides time off to recover from childbirth, whether somebody's recovering from a vaginal or a C-section delivery. And this isn't bonding leave as is indicated in the FMLA, but it's instead leave so that the birthing parent can recover. Many who aren't eligible for the FMLA will still be able to get unpaid and protected time off for recovery now with the PWFA. And it's an incredibly important aspect of the PWFA that not many people know about, so we wanted to highlight it here. Apart from FMLA as well is the Americans with Disabilities Act we've touched on as well. It makes it illegal for employers with 15 or more employees to discriminate because of somebody who has a disability in the workplace. It's the same general principle that we've discussed before, requiring a reasonable accommodation to those that request it, unless the employer can demonstrate that there would be an undue hardship, meaning that it's something very difficult or expensive to do. And typically when workers request an accommodation, they must still be able to complete the basic duties that their job entails. And a disability under the meaning of the law here is broad in scope. It can be a physical or mental impairment that substantially limits one or more major life activities. So while it's robust for people that have disabilities in the workplace, part of the problem with the ADA here in the pregnancy context is that it doesn't apply to healthy pregnancies or situations of wanting to prevent health problems before they even start. And also courts have interpreted even very serious and complicated pregnancy disorders as not counting under the ADA within the meaning of a disability. So that is why the PWFA might be even more robust here in certain contexts, but it's still important to keep in mind that there may still be ADA claims present for some folks here when examining their own conditions and their pregnancy scenario. And so aside from these federal protections that are present and in addition to the PWFA and PUMP like we talked about before, we also wanted to lastly flag that there may be state equivalents of these laws, so like we've briefly broken down with PWFA. Apart from those, workers might be eligible for paid leave benefits and protections, such as the right to take paid family leave, paid medical leave, sick time, disability leave, etc. It can really vary depending on your state what these systems and benefits are called. But we wanted to just flag that we have a comparative chart on our website that breaks down paid leave programs, and separately we have a workplace rights hub that will summarize similar discrimination and accommodation protections all at your state level, which will vary according to where you are. And so how we can help. Lastly, I'm excited to be here today because I'm one of the attorneys on our staff here at ABB who works on our free and confidential legal helpline. We provide services in English and in Spanish. So I hope that you all here today will spread the word to workers that you know or represent about our helpline, and hopefully it can be a valuable resource to you all. A little bit more about what we can help with. We've broken down our issues before, but pregnancy accommodations and pumping that come to mind, caregiver discrimination, pregnancy discrimination, paid sick time, paid family leave, temporary disability insurance, depending on certain states, disability accommodations, like we discussed, FMLA, leave and coverage, and other labor protections that might be relevant to these issues can also come into the realm of our discussion. In the event that your issue falls outside of ABB, we can also provide you with referrals and resources, so our hope is not to leave anybody empty-handed. And lastly, just flagging again, this is the Workplace Rights Hub on our website. That's what the landing page will look like. You can feel free to go to our link, abetterbalance.org/know-your-rights, or even after reviewing the Workplace Rights Hub, people will often still have questions, so they can feel free to call us at the legal helpline number we have here at the bottom, and it's also in all of our slides. We'll follow up as well with more information on how to call the helpline. And lastly, we're plugging it one more time, the helpline number, and we invite everybody to reach out and connect with us on socials if you're not already following us. And our website just has tons of resources as well for those that are interested in educating themselves on their own time.
All right. Well, thank you all so much for your attention. We've already started getting a lot of really great questions, and please feel free to continue sharing questions. We are going to try to take as many questions as we have time for before 4 p.m. So I'm just going to jump right in. First, someone asked, does the Pump and Pregnant Workers Fairness Act cover part-time employees? Absolutely, yes. It does cover part-time workers. Pregnant Workers Fairness Act also covers applicants, and it's really important for folks to know this covers part-time employees as well, and undocumented workers too. Moving on to another question that someone asked. So I know Lisa talked a little bit about the Pregnancy Discrimination Act, and a lot of the issue around the Pregnancy Discrimination Act, which someone raised a question about, is that in order to get accommodations under the Pregnancy Discrimination Act, people needed to show that there was a comparator in the workplace, so someone else in their workplace who is getting an accommodation in a similarly situated, in order to get their own accommodation. The beauty of the Pregnant Workers Fairness Act is that you no longer need to show that someone else in your workplace was getting an accommodation in order for you to get an accommodation. So long as you have a limitation related to pregnancy, childbirth, or a related medical condition, and you need an accommodation, your employer has to engage with you in the interactive process to try, which really interactive process is just a fancy way of saying a real conversation back and forth over what type of accommodation works for both them and for you as well. And so I think it's a really important feature, a really critical feature of the Pregnant Workers Fairness Act, which is that workers no longer need to be looking around their workplaces, figuring out who else was accommodated in order to get their own accommodation. So that's a really key feature. Someone else also asked about the concept of essential functions. So as folks may know, under the Americans with Disabilities Act, which, like I said, we borrowed many of the concepts from for the Pregnant Workers Fairness Act, there's a concept that you need to be able to perform the essential functions of your job in order to be a qualified employee, and the accommodations have to be such that you can perform the essential functions of your job. This is a really critical area where we deviated from the Americans with Disabilities Act. So under the Pregnant Workers Fairness Act, we were very specific in this because we knew that there might be times where essential functions, a pregnant worker might not be able to perform their essential functions, but it might be for a temporary period. And therefore, those essential functions should be excused and they should still merit the accommodation. Even so, under the Pregnant Workers Fairness Act, even if you're not able to perform some of your main job duties, which again are referred to as essential functions, it may still be possible to receive accommodations so long as you're able to perform your job in the near future, and you only need that accommodation for a temporary period. So that's a really key feature of the Pregnant Workers Fairness Act that isn't a feature of the Americans with Disabilities Act. It was because we know that these are often discrete defined periods where someone might need an accommodation and they should still be eligible to get these accommodations and not pushed out of their job should they not be able to perform one of their major job duties. So thank you for the person that raised that question. Another question that has come up is somewhere where there's been some confusion is that a lot of folks, and I've seen a lot of information about this, think that the PUMP Act provides coverage for 2 years following childbirth. And the reason that folks think that is because there was a version of the legislation, the version that passed the House of Representatives, that did provide coverage for up to 2 years. Unfortunately, in the final version of the law, the coverage is up to 1 year. So that was not something that was able to get over the finish line. So anytime you see information that the federal law actually covers up to 2 years, that's unfortunately misinformation. Please know that we pushed for that we wanted that, but unfortunately that wasn't something that we were able to get in the final version of the law. That said, like I mentioned before, there may be state level protections that go beyond federal law. For instance, New York provides protections for up to 3 years following childbirth for break time and space. And so you might have protections under state law that you don't have under federal law. So I just want to clarify that and say that I'm sorry about that. But I also it's really important that we provide correct information, even if it's not the information, we hoped would be in the law or the protection, but we have to ensure that workers have the accurate information. So another question that came up is clarifying. So someone asked about the state of Wisconsin and pregnant workers fairness and PUMP. So in a state like Wisconsin, right now, the PUMP Act, which extended break time and space for lactation to many millions more workers, is in effect. So for instance, if there's a teacher in Wisconsin that right now needs break time and space, they are covered under the PUMP Act this minute. If they needed an accommodation related to their pregnancy right now, the Pregnant Workers Fairness Act is not in effect until June. However, like Lisa said, there are other protections like the Pregnancy Discrimination Act, like the Americans with Disabilities Act, which may provide protection. So I don't want folks thinking, oh, before June, there's nothing that can help those I work with, because there are federal protections. There are, and again, there are potentially state level pregnant worker fairness laws that are still in effect that can provide support as well. So I want to make sure folks know. Now, someone else and a couple of folks have asked questions about undue hardship, which I've referred to a couple of times. And undue hardship means if something is incredibly difficult or incredibly expensive, that's really significant difficulty or expense. And the truth is that that is not one standard. That standard looks different for different employers, right? So a multinational corporation might have very different ability to cover certain types of accommodations than an employer with 16 employees. And so it's really a case-by-case analysis that the agency does, that a court does, to determine what an undue hardship would be. But it's really dependent on the employer's capacity. But like I said, it's also, we want to make sure that the protection is as solid for workers. And so generally speaking, undue hardship is not just handed out willy-nilly, but you really need to look at what the employer can do. And the reason for that also is because, again, it's not as though a worker comes to their employer and says, I want this, and the employer has to say, yes, I will give you exactly what you want. It's the conversation, right? An employer might say, I'm really sorry, I can't provide X, but let me work with you and I can actually provide Y and meet your needs. Like, let's talk about what it takes to meet your needs, which is why undue hardship comes later, because there should be lots of different versions of what an accommodation can look like before we even need to get to the undue hardship. Someone else asked, I'm just trying to go through what this means, a bunch of our questions. Okay, just to clarify, someone said the Pregnant Workers Fairness Act, does that cover breastfeeding as a pregnancy-related condition? And the answer is yes. So lactation is a related medical condition. And so someone who needs a lactation-related accommodation has hopefully the protections of the PUMP Act for break time and space. The Pregnant Workers Fairness Act An accommodation can also be break time and space, but again, it can be a broader universe as well, right? So if someone needs an accommodation, like I said, related to their uniform, they need to wear a bigger uniform or a less tight fitting uniform because they're breastfeeding, then that could be a lactation accommodation that's available under the Pregnant Workers Fairness Act. If I'll give example too. So the Pump Act doesn't require refrigeration. Certainly that's something that many employers like to provide for workers. It can really help. The more an employer provides to create a space that's conducive to pumping, the quicker breaks go, the more streamlined it is. So it's actually beneficial for both employers and employees. But it might be the case that exploring refrigeration options could be something that's discussed under the Pregnant Workers Fairness Act rather than the Pump Act, which doesn't mandate refrigeration. So that's another sort of way that the two laws can work together. Another question we got is around undocumented workers. So, and even if a state level protection doesn't cover undocumented workers with the federal, and again, the answer is yes. So undocumented workers are covered under the Federal Pump Act and the Federal Pregnant Workers Fairness Act. There might be certain questions that arise related to that. So we really encourage folks to call us with questions around undocumented workers. We never take down that information. It's completely confidential. Obviously, we're not a government entity, so we know some undocumented workers are scared to call government entities. We strive to be a safe space for undocumented workers. And like Lisa shared, we speak to folks in both Spanish and English and try to accommodate other languages as well. So please be in touch with us with questions around undocumented workers. All right, looking at some more questions here. So someone asked about the benefit of continuing state level advocacy to match the federal PWFA. We would encourage folks to talk with us if they're interested in pursuing additional state level advocacy. We want to be in touch with folks that are interested in that, but I think it's important to think about advocacy in different ways. So there's certainly advocacy around passing new legislation, of course, but there's also advocacy that can be done with state agencies. So is it coming up with additional guidance that the state can come out with? Is it working with the state to do state level outreach? Is it working with regional EEOCs along with state agencies to get the word out about the law? So I think please come to us with questions about state level advocacy. If there are state level agencies that they want to work with, in addition to legislative advocacy, because the umbrella can really take on a broad form, and we're excited to work with folks on thinking through ways that folks can continue to engage on the state level. And I will be sure you'll be getting a follow-up email from Lisa and I, and you'll have my email, you'll have Lisa's email, and we want to take further questions that folks have. If folks are interested in additional advocacy, we want to be sure to work with you on that and really be as much of a support and resource as we can. And I know we're coming to time, and so just want to reiterate a huge thank you to everyone. This has been not just a moment, but a movement, and it's a movement that will continue. We've built so much together. We've made the case together for why Congress needed to pay more attention to pregnant and postpartum and nursing workers, and why it's such a key feature of maternal health, of infant health, of economic security. And I just want to thank everyone for being in this movement with a better balance. And you'll be hearing more from us soon, and please don't be strangers. So thank you so much, and take care, everyone.
Thank you, everyone.